Hi everyone, my name is Asim Dietrich. I'm Supervisory Attorney for Investigations Monitoring and Accountability at the Arizona Center for Disability Law. And today I'll be presenting on disability discrimination under the ADA, or Americans with Disabilities Act. So first off, just a little bit about the Arizona Center for Disability Law. So we are a nonprofit law firm that assists Arizonans with disabilities to promote and protect their legal rights to independence, justice, and equality. And we envision a society where people with disabilities have full acceptance without barriers. And ACDL is also what's known as a protection advocacy system. So we're a federally funded organization that works to protect people with disabilities from abuse and neglect and advocates for the rights of people with disabilities. So ACDL is the designated protection advocacy system for Arizona. So the discussion topics for today include what does ACDL do? How does the Americans with Disabilities Act, or the ADA, define disability, what the ADA requires, and how the ADA is enforced. So some of the areas that ACDL can assist people with disabilities are abuse and neglect, access to health care, access to mental health care, making sure that people with disabilities have the assistive technology they need, employment, so looking at issues related to employment discrimination, and then voting rights, making sure people with disabilities have access to a private and independent vote, transportation issues, and then we also look at issues related to fair housing and accessibility. So that could be accessibility to public accommodations or to public entities, education, and emergency preparedness. And so that was just a brief introduction of the different areas in which we work. Now I want to go over what a disability is under the ADA definition. So the ADA defines a disability as a physical or mental impairment that substantially limits one or more major life activities. And major life activities include things like walking, breathing, seeing, speaking, hearing, caring for yourself, learning, your relationships with others, and it's not an exhaustive list. So major life activities can include basically anything that is an activity that people do during their daily life. And that major life activities also include the operation of bodily functions. So things such as respiration, circulation, neurological function, muscular function, function of the immune system. So all of those bodily functions are also major life activities. So if there's a physical or mental impairment that substantially limits at least one of these activities, that's considered to be a disability. So under the Americans with Disabilities Act, Title II covers public entities. So under Title II of the ADA, no person with a disability can be discriminated against by a public entity based on their disability. And also no person with a disability can be excluded from participating in services, programs, or activities of a public entity because of their disability. And additionally, the Title II of the ADA provides that no person with a disability can be denied the benefits of services, programs, or activities of a public entity because of their disability. So Title II prohibits discrimination, but then it also prohibits people with disabilities being denied the benefits or the programs that a public entity offers. And discrimination under Title II of the ADA includes the failure to provide a person with a disability reasonable accommodations necessary to give the person access to the services provided by the public entity, unless the accommodation would fundamentally alter the service. So unless a reasonable accommodation would fundamentally alter the service being provided, that reasonable accommodation must be provided to provide people with disabilities access to the services of a public entity. And then public entities are defined by Title II of the ADA as any state or local government or any department, agency, instrumentality of a state or local government. So it could include, for example, the state of Arizona. It could include Pima County, Maricopa County, the city of Phoenix, city of Tucson. All of those are examples of state or local governments. And then it could include departments or agencies within the state or local government. So something like the Arizona Medicaid program access is considered a public entity because it's an agency within the state government. So some examples of public entities are court buildings, services provided by or paid for by Medicaid, the Division of Developmental Disabilities, schools, libraries, and any government building or service or program or activity provided by the government. So some additional requirements of Title II. In providing a benefit or service, a public entity may not directly or through a contract do the following on the basis of disability. So that means a public entity cannot do these things itself, and it cannot contract with a private service provider or a private contractor to do these things. So public entity, directly or through a contract, cannot offer a benefit or service that is not equal to that offered to people without disabilities. And also public entities cannot provide a benefit or service to a person with a disability that is not as effective in affording equal opportunity to obtain the same result, gain the same benefit, or reach the same level of achievement as others. So the benefit or services being provided to a person with a disability must afford equal opportunity to obtain that same result or gain the same benefit. And also public entities cannot provide separate benefits or services to people with disabilities or to any group of people with disabilities. So Title II prohibits public entities from segregating people based on having a disability or based on the type of their disability. That's prohibited by Title II. And this is prohibited unless the separate benefit is necessary to provide people with disabilities benefits or services that are as effective as those provided to others. So if the goal is, if the only way to provide services that are as effective is to provide people with disabilities separate benefits, then that may be necessary. And the public entities also cannot aid or perpetuate discrimination against people with disabilities by providing assistance to an agency, organization, or person that discriminates against people with disabilities. So public entities are prohibited to discriminate against people with disabilities, but they're also prohibited from aiding in discrimination against people with disabilities. And then other rights under Title II of the ADA, public entities cannot deny a qualified individual with a disability the opportunity to participate as a member of a planning or advisory board. So, for example, if it's a advisory board through the Medicaid plan where members of the public are able to be on that advisory board. People with disabilities cannot be denied that opportunity. Another example might be one of the independent oversight committees, such as the DDT, Independent Oversight Committee. People with disabilities cannot be prevented from serving on those types of committees. And the public entities also cannot otherwise limit a person with a disability in the enjoyment of any right, privilege, or opportunity enjoyed by others receiving the benefit or service. However, under Title II of the ADA, there are some situations in which separate programs may be permissible, but they have to be the specific situations outlined in Title II. For example, even if a separate or different program or activity is permissible under the ADA, a public entity cannot deny a person with a disability the opportunity to participate in the program or activity that is not separate or different. So simply because there is a separate program that may be allowed under Title II of the ADA, the person with a disability still must be afforded the opportunity and the reasonable accommodations to participate in the same program. And then just some information on the unintentional discrimination. So public entities cannot directly or through a contractor use criteria or methods of administration that have the effect of subjecting people with disabilities to discrimination. So there doesn't have to be some kind of disability animus or some kind of situation where the public entity just simply doesn't want to serve people with disabilities, even if they use methods of administration that have the effect of disability discrimination. That's enough for it to be discrimination under Title II. And then defeating objectives of a program. If a public entity may not use criteria or methods of administration or locate services with the purpose or effect of defeating or substantially impairing the objectives of the program being offered with respect to people with disabilities. So, for example, if it's a housing program, or if it's Medicaid services, or if it's the services of a state-owned medical facility, those types of facilities cannot use methods of administration or locate their services where people with disabilities may not be able to access those services. And then unintentional discrimination in methods of administration. So public entities cannot use methods of administration that perpetuate the discrimination of another public entity if both are subject to common administrative control or are agencies of the same state. So one state agency in Arizona cannot perpetuate the discrimination of another state agency based on methods of administration. So any and all state agencies have to make sure that they comply with Title II of the ADA and do not perpetuate discrimination. And then public entities also cannot locate facilities in the state that has the effect of excluding people with disabilities, denying them the same benefits or subjecting them to discrimination. And then just a word on eligibility criteria. So the Title II prohibits public entities from imposing eligibility criteria that screen out or tend to screen out people with disabilities from fully and equally enjoying any service or program. Like, for example, applications to receive services or to be enrolled in a program cannot include disability-related questions that would screen out people with disabilities from being eligible. So those types of criteria for applying for any type of service from the state or local government must make sure that they do not screen out people with disabilities and make sure that people with disabilities have the ability to meet the eligibility criteria and receive those services. And this is required unless the criteria can be shown to be necessary for the provision of the service or program being offered. So, for example, if it's a service or program specifically defined to serve people with disabilities, then the eligibility criteria can be disability-based. For example, the Division of Developmental Disabilities only provides services to people with autism, cerebral palsy, epilepsy, and other conditions that are developmental disabilities. So if someone has a physical disability alone, that question could be asked on the DDD application because you have to have a developmental disability to receive services from DDD. So that's a situation where certain disabilities can be screened out if it's part of the services being offered only to specific disability groups. And then assisting people with disabilities. So nothing in the ADA can provide the basis for a claim that someone without a disability was subject to discrimination because of a lack of disability. So basically that has to do with claims of reverse discrimination. So someone who doesn't have a disability does not have a disability discrimination claim under the ADA. Because the ADA protects people who meet the definition of disability. So if someone does not meet that definition, they cannot be discriminated against under the ADA. And this includes a claim that a person with a disability was given a reasonable accommodation that was denied to an individual without a disability. So the requirement in Title II of the ADA and the requirements in the ADA in general that reasonable accommodations be provided for people with disabilities. That is not giving a person with a disability any kind of special access or special treatment. Reasonable accommodations provide people with disabilities the same equality of opportunity and equality of access that people without disabilities have. So reasonable accommodations really just level the playing field for people with disabilities and make sure they have the same opportunities and benefits of the services and programs of public entities. So it is not discrimination to deny a person without a disability the same accommodation. And then requirements around effective communication. So public entities are required to provide people with disabilities communication that is as effective as communication with people without disabilities. So for example, people who are deaf or people who are blind have to be able to access communication that is as effective as those without disabilities. And that could even apply to people who are nonverbal or who have other communication impairments. So public entities must provide people with disabilities, auxiliary aids, and services to allow people with disabilities an equal opportunity to participate in and enjoy the benefits of the service or program. So what that means is even if you're a person, for example, with autism, who receives services through DDD, and you have the co-occurring disability of deafness, DDD as a public entity has to make sure they provide a sign language interpreter or some other communication aid or service to assist with effective communication. So even if the public entity already serves people with disabilities, they have to make sure that they serve people who may have multiple diagnoses that may affect their ability to communicate, and make sure those individuals have the same equal opportunity to communicate. And then auxiliary aids and services are devices or services that make spoken or written information available to people with disabilities in a way that they can access and understand the information. So services like ASL interpreters, American Sign Language interpreters, video remote interpreting, which is where a sign language interpreter is made available through a video call and they interpret the conversation. Large print for people who have vision difficulties, Braille for people who are blind, and other aids and services to make spoken or written information available to people with disabilities. And it could even include materials written in more simplified language or plain language for people with intellectual or developmental disabilities. So anything that makes that spoken or written information more easily accessible and available. And then public entities can decide what type of auxiliary aid or service to provide, but they are required to give primary consideration to the request of a person with a disability when determining the type of aid or service that is necessary. For example, many people who are deaf are fluent in American Sign Language, but are not fluent in written English because ASL is their primary language. So in that situation, primary consideration has to be given to the person who is deaf because they have informed the public entity that they are not fluent in written English. So some type of aid or service has to be provided which provides them access to an ASL interpreter, because primary consideration has to be given to the fact that ASL is their first language. And even if the requested auxiliary aid or service is not available, the public entity must provide an alternative that still makes effective communication possible. So even if the exact requested uh, aid or services is not available, as effective communication still has to be made possible. So, for example, if someone who is deaf requests a live in-person ASL interpreter, but that in-person interpreter is not available, then the public entity must make sure that they have an alternative. For example, that video remote interpreting, that they have that available as an alternative or another alternative to provide ASL interpretation. And then some more information around sign language interpreters. So public entities cannot require someone accompanying a person with a disability to interpret or facilitate communication. So the person accompanying the person who needs interpretation cannot be required to interpret. And unless it is an emergency with an imminent threat to safety or welfare, or the person with a disability requests that the companion interpret or facilitate communication. So those are the only times in which a person or a companion can be required to interpret for a person with a disability. If it's an imminent threat to safety or welfare, or the person requests that the companion interpret. Otherwise, the facility has to provide interpretation or facilitate communication. And then child interpreters. Public entities cannot rely on a minor child to interpret, except in emergencies with an imminent threat to the safety or welfare of an individual or the public. So unless it's an imminent threat to safety or welfare, a person with a disability cannot be required to have their child interpret. Um, and this is, and allowing a child to interpret in an emergency can only occur when there is no interpreter available. And then associational discrimination. So a public entity cannot exclude or deny equal services or programs to someone because of the known disability of an individual they have a relationship or association with. So, for example, if someone applies for a housing voucher for their family, for example, that person cannot be denied a voucher because one of their family members that will be living in the housing has a disability. So that's just one example, but there are many examples where if someone is an associate, is a friend or family member of a person with a disability, they cannot be discriminated against because of that association. And then Title II of the ADA also includes the integration mandate, which is that benefits, programs, and services must be provided in the most integrated setting appropriate to the needs of the person with a disability. And the most integrated setting appropriate is defined as a setting that allows the most interaction between people with disabilities and people without disabilities who are not staff. So in the integration mandate really, under most circumstances, requires that people with disabilities receive services within the community. So that was everything I had about Title II of the ADA. Just a brief overview of of the rights of people with disabilities and the obligations of public entities. Now I'm going to shift over and talk about Title III of the ADA, which has to do with public accommodations. So Title II of the ADA provides that no person with a disability can be discriminated against because of their disability by anyone who owns, leases, or runs a place of public accommodation in the full and equal enjoyment of the goods, services, etc. of any place of public accommodation. So no person with a disability can be discriminated against because of their disability by anyone who either leases or runs or even owns a public accommodation in the equal enjoyment of the goods and services available. And then places of public accommodations are numerous, and some examples are listed in Title III of the ADA. So a professional office of a healthcare provider, a hospital, or other service establishment. So a hospital, a facility that provides services to people with disabilities could be a day treatment program or even an overnight facility such as a group home. It could be basically any private organization where healthcare services are provided or other services are provided. And in hotel, motel, or other place of lodging, a place serving food or drink, a place of exhibition or entertainment, so movie theaters or sports arenas, a place of public gathering, any privately owned provider of goods, services, and programs. So really any private business that provides goods, services, or programs to the general public is considered a public accommodation and are required to comply with Title III of the ADA. So discrimination under Title III includes a number of things. So imposing eligibility criteria that tend to screen out people with disabilities from full and equal enjoyment of anything a public accommodation offers to people without disabilities. The failure to make reasonable modifications in policies, practices, or procedures to afford people with disabilities full and equal enjoyment of anything the public accommodation offers to other people. So a good example of the failure to make reasonable accommodations, maybe a movie theater that does not offer closed captioning or narration for people who may be deaf or blind. So they offer the screening of movies to people without disabilities who can access them without any additional modifications. But people who are deaf may need open captioning, or people who are blind may need narration. So those items have to be provided as reasonable modifications so people with disabilities can have equal enjoyment of the movie theater's services. Another example might be someone who needs a service animal. So that would be allowing a service animal into a restaurant or retail facility would be a reasonable modification, allowing a person with a disability the full and equal enjoyment of that business's services. So those types of accommodations must be provided. And then also under Title III of the ADA, public accommodations and contractors, so organizations that are contracted with public accommodations, cannot deny people with disabilities participation in or the benefit from good services or facilities of a place of public accommodation. So it's discriminatory to deny people with disabilities participation in the goods or services of a public accommodation, but it's also discriminatory to deny people with disabilities the benefits of the goods or services of a place of public accommodation. And then, so, so basically what that means is it's not enough to make a public accommodation accessible to people with disabilities, but they have to be able to receive the same benefit from those goods and services. And then public accommodations and their contractors may not provide an unequal goods service or facility to people with disabilities. So, for example, restaurants cannot have a disability section, and it's all people with disabilities, and then another section where people are allowed to mix together. So that a restaurant has to make sure that their services are provided equally, and that every area of the restaurant is accessible to people with disabilities. And then additional forms of discrimination include the failure to provide auxiliary aids and services such as large print or braille materials, sign language interpreters, augmentative communication, when it is necessary to allow people with disabilities to fully and equally enjoy anything the public accommodation offers to other people. So similar to Title II of the ADA, auxiliary aids and services have to be provided to people with communication impairments when necessary to allow them to fully and equally enjoy the service. And then the failure to remove architectural barriers and communication barriers that are structural in nature in existing facilities is considered discrimination, and the failure to make new facilities accessible to persons with disabilities. So even if a building or facility of a public accommodation was built before signing of the ADA in 1990, so even if the building was built before 1990, Title III of the ADA requires the removal of any architectural barriers. So for example, if the building doesn't have a ramp to allow wheelchair accessibility, then the public accommodation is required to remove that barrier and include a ramp, even though that building was built before 1990. And then if it's a communication barrier, another example might be for a wheelchair user and the public accommodation has a very high counter, and the public accommodation, again, their facility has been there before 1990. That barrier must still be removed, and a lower counter must be available so people who are wheelchair users can access the facility. Or even making restrooms accessible. Even if it's older facility, architectural barriers have to be removed so that restrooms can be made accessible for people with disabilities. And then, of course, all new facilities since 1990 have been required to be built to be accessible to people with disabilities. And then Title III of the ADA has requirements for integration, just like Title II. So public accommodations are required to provide people with disabilities good services and facilities in the most integrated setting appropriate to the needs of the individual. Again, based on the needs of the person with a disability, the public accommodation has to maximize the opportunity for people with disabilities to come in contact to people without disabilities, other than staff members of that facility. So this could also apply to private facilities that provide services to people with disabilities. So for example, if it's a private residential facility, for example, it has to maximize the integration of the people with disabilities appropriate to their needs. So they have to have enough of an opportunity, even if they reside in a residential setting, people with disabilities have to have the opportunity to go out into the community and to have access to the community and to be able to interact and integrate with the community at large and with people without disabilities. And then that could also apply to private medical facilities. They have to make sure that separate services are not provided to people with disabilities. They have to provide people with disabilities reasonable accommodations, but those accommodations have to be designed in a way to make sure services are provided in an integrated setting. And then, again, even if a separate or different program complies with the ADA, a person with a disability cannot be denied the right to participate in the same program or activity as people without disabilities. And then public entities cannot directly or through a contractor use criteria or methods of administration that have the effect of disability discrimination. Again, even policies that have the effect of discrimination can be disability discrimination under Title III of the ADA. So public accommodations cannot directly or through another contractor or third party that they contract with have the effect of discriminating on the basis of disability. So it's discrimination for public accommodation to say, well, we know we don't allow animals, but we do that for everybody. Nobody is allowed to bring an animal into our facility. Well, that's a criteria that denies to people with disabilities who have service animals, that has the effect of denying them access, and has the effect of disability discrimination. So a public accommodation can never just have a blanket policy. They have to provide reasonable accommodations to their policies when necessary for people with disabilities. And public accommodations cannot utilize criteria or methods of administration that perpetuate the discrimination of others who are subject to common and administrative control. So, for example, two companies that may have the same parent company, those companies cannot perpetuate one of them discriminating, even if the other doesn't. So, for example, if there are two restaurants, both owned by the same company, one restaurant cannot allow service animals and then, develop policies that the other restaurant is able to deny service animals. Because they're both under the same company, they both violate the ADA by allowing the other to deny access to people who have service animals. So that's one example. And then associational discrimination, public accommodations cannot deny goods, services, or programs or other opportunities to someone because they have a relationship or association with a person with a disability. So again, if a person without a disability, for example, is accompanying their friend or family member with a disability in a public accommodation, that that person cannot be discriminated against because they're with someone with a disability. So that's just some brief information on Title 3 of the ADA and the rights of customers of public accommodations and the responsibilities of public accommodations. Now I'm just going to go over some information on how the ADA can be enforced. So, someone who feels like they've been discriminated against under the ADA or have been denied needed accommodations can make a complaint with the public accommodation or public entity itself. Most public entities are required to have some type of ADA coordinator who can accept complaints. So you can always make a complaint directly with the public accommodation or public entity. But if that process doesn't go anywhere, or if you feel like your complaint is not going to be taken seriously, you can jump immediately to filing a charge of discrimination with the U.S. Department of Justice Disability Rights Section, or the DOJ. Or you can file a charge of discrimination with the Arizona Attorney General's Office, Civil Rights Division, or ACRD. So any complaint you file, you don't have to make a complaint with the public accommodation or public entity before filing a charge with the DOJ or the ACRD. So you can go directly to that step if you would like. And then it's a 180-day deadline after the date of discrimination to file a complaint with the DOJ or the Arizona Civil Rights Division under Title 2 or 3 of the ADA. And then the deadline to file a lawsuit typically is within 2 years of the discrimination under the ADA. So you could file a lawsuit within 2 years of discrimination if you would like to do that. And then you can contact ACDL for additional information on your enforcement rights under the ADA. And then other ACDL information is also available. You can visit our website at www.azdisabilitylaw.org, or you can visit our social media sites on Facebook and Twitter. And some additional resources. So you can get more information about the Department of Justice Disability Rights section. You can go to their website, justice.gov/crt/about/DRS. You can also visit the Arizona Civil Rights Division website to get more information on filing complaints. That website is azag.gov/complaints/civil-rights. Or you can go to ada.gov, which is the Department of Justice website that has all kinds of information on the requirements of the ADA and different types of guidance and technical assistance about the ADA. And then you can also, for examples of different types of accommodations, you can visit the Job Accommodation Network's website, and their website is askjan, ASKJAN, .org.